already today on the concepts of clean rooms and healthcare enforcement. And now we have a fantastic panel here today on enforcement from a data privacy and protection perspective in Europe. And we have two outstanding panelists who also know each other well, which is great. And I'm going to have our two panelists introduce themselves, and then we're actually going to exit stage right here and let them have a proper conversation on the subject. So first of all, I'd like to introduce Anna Morgan, who's currently with Bird & Bird and formerly of the Irish Data Protection Authority, and Cian O'Brien, who's currently the deputy at the Irish Data Protection Authority. And as we always do, Anna and Cian, if you wouldn't mind, just give a few minutes of background on yourselves and how you came to the position, and then I will be stepping out and letting you have a proper conversation. So Anna, if you don't mind, I'll introduce you first. I'll let you go first.
Thank you so much, Justin. And thank you very much to you and your team for the invitation to be here with you all today to talk about enforcement, looking forward and looking back over the last year in Europe from a GDPR and data protection perspective. So as Justin said, I was formerly at the Irish Data Protection Commission for 6 years, from 2016 until 2022. So I was a deputy commissioner and the head of legal affairs, the general counsel for the commission during that period. So during that time, I had the real pleasure of working very closely with Cian. Cian and I were on the same team, and it's great to be on stage now with him, albeit in a slightly different role. I left the Irish Data Protection Commission nearly a year ago, and I've gone back into private legal practice in Ireland, and I was one of the co-founding partners of the Irish office of Bird & Bird, which is a law firm which is very much focused on technology and innovation, and I'm leading the privacy and data protection practice in Ireland. So I'll hand over to Cian to introduce himself.
Thanks very much for that, Anna, and thank you, Justin, and for the whole team for the invite here today. It's great to be here. My name's Cian O'Brien. I'm a Deputy Commissioner in the Data Protection Commission of Ireland. I joined DPC in 2019, and I joined Anna's team at that point. So it's great to be here with Anna again today as well. We've had a very busy year in 2022 in the DPC, so I think talking about enforcement in Europe is a very pertinent topic at the moment, as we turn into our 5th year of GDPR enforcement. So very much looking forward to getting into the details.
Terrific. Okay, well, thank you both very much for joining us here today. As I said, it's nice that you know each other so well. And I'll turn it over to you, Anna, and Cian for a conversation. We'll see you shortly.
Thanks, Justin. So let's kick off. Thank you. So maybe just to start, I know we're going to look ahead as our conversation emerges, and we're also going to look back at what has happened to date and some of the big developments in the European and the Irish data protection landscape. And so maybe if we start off by doing a bit of a survey over the last year, over 2022, because what a year it has been. You've been super busy in the Data Protection Commission. If I look back to the point at which I left, which was April last year, such a huge amount has gone on since then. A lot of it has been very succinctly detailed in the annual report, which was published in the last number of weeks. And that gives, I suppose, an indication of the level of activity which has been going on over the last year across multiple areas of GDPR enforcement and the DPC's supervision, consultation, and enforcement functions. So I suppose as we kind of look back and as you cast your mind back to all that has gone on over the last 12 months, 17 inquiries concluded, 7 of those relating to big technology companies, groundbreaking decisions on very kind of critical topics under the GDPR, like data protection by design and default, the processing of children's data. We saw, of course, the first decision in Europe on that topic. We've also seen seminal decisions on transparency and legal basis. So really a huge scale of activity across a range of really important topics. We've also seen a lot of fines levied, and of course, there's been much said about those in the press internationally. So when you take into account all of those different strands of activity and development, what is it that jumps out at you most from 2022, Cian?
Thanks for that, Anna. That's a great introduction to a really busy year that we have. As you mentioned, we concluded 17 large-scale inquiries in 2022. And as part of those inquiries, we imposed over €1 billion in fines. And just to put that figure into context, around the entire European Economic Area and the UK combined, approximately 1.6 billion in fines was levied. So the Irish Data Protection Commission was responsible for over 2/3 of all fines issued in 2022. So it certainly has been an extremely busy year, but the fines, while very significant, what's perhaps even more significant than the fines are the other corrective powers that were exercised in those large-scale inquiries that concluded in 2022. So people may be familiar with our decision into Instagram's processing of children's personal data. Very significant fine in that case of €405 million. But there was also a significant order made by the Data Protection Commission requiring Instagram to conduct data protection impact assessments, and also requiring Instagram to notify data subjects of certain changes. Another significant fine came in the context of the Facebook scraping decision, which we might talk about a little bit later, but that fine was €265 million. But also, really crucially, an order requiring Facebook to make changes to certain features which allowed for each individual's phone number and email addresses to be publicly searchable, which then enabled the scraping in question to occur, which resulted in a data set of over 500 million people's personal data worldwide being distributed on the internet. We recently concluded some very significant decisions concerning the reliance on Article 6.1b of the GDPR as a lawful basis for processing personal data. And that basically provides for a lawful basis where processing is necessary to fulfill a contract. We imposed approximately €395 million in fines. But again, really crucially, an order and orders requiring Facebook, WhatsApp, and Instagram to bring their processing into compliance by identifying a valid lawful basis. So indeed, you're correct, Anna, that 2022 really was a very busy year for the DPC. We've managed to bring clarity to a lot of very key provisions under the GDPR. Through our enforcement action, we've imposed a very significant quantum of fines, and we've also exercised other very significant corrective powers in 2022.
Thanks again. So you've mentioned a few things there that I think we will certainly revisit later on in our conversation. Some kind of core topics around compliance orders and directions, and we're going to dig into the importance of those, I suppose, and what they mean for industry and for businesses that are being regulated. And you've also mentioned, you've given us a kind of a high level overview of some of the critical decisions that have been issued by the DPC concluded during 2022. And again, I think it'll be really useful to our audience and to those listening at home to have a kind of a more in-depth look at the key aspects of those decisions. But maybe for now, if we just continue our horizon scanning, we've looked back at what has been going on in 2022. And I think it's also useful maybe to look ahead to 2023 and what is on the books for the DPC and I suppose for the European data protection landscape. So some of the inquiries you've talked us through that were brought to closure in 2022 cut across really important topics. But I think it's also useful that in the DPC's annual report for 2022, you actually set out those decisions which are essentially pending and which I presume may come to conclusion during 2023. And they are decisions that are to be taken under the Article 60 process of the GDPR, and that is, of course, the co-decision making process, which is provided for in cases concerning cross-border processing of data. And I did notice in that annual report that you've mentioned there is a decision which is at the Article 60 stage, so in that co-decision making stage. There's one in relation to TikTok. So that's the second decision relating to children's data. You mentioned the Instagram one a few minutes ago. There's also that long-awaited Meta decision in relation to data transfers, which of course has had a huge amount of attention paid to it in the media and internationally in terms of what that means for the transfer regime. And then I also noticed that there is a further Article 60 decision in connection with Yahoo and its transparency for its users, all again pending before the European Data Protection Board in that co-decision making process. So clearly lots and lots of big ticket activity due to happen behind the scenes as we look ahead over the next kind of 9 or 10 months. If we were having this conversation in April 2024 and you were looking back on what has happened, what do you think you would be talking about? So I suppose it's another way of saying, what are going to be the biggest, hottest topics? Is it going to be some of those things that I mentioned, or is it something else entirely?
Yeah, sure. And I think it really will be the issues you mentioned. So as you mentioned, we have 22 large-scale cross-border inquiries currently ongoing. And I think you mentioned the annual report. We published our annual report last month, and that does indicate what issues are being pursued in each of those inquiries and what stage of enforcement we're currently at. And I think even looking at the summaries in the annual report, what's very clear is that the Data Protection Commission of Ireland is pursuing the issues of greatest consequence to data subjects and is seeking to bring clarity to the issues of greatest consequence under the GDPR. So, Anna, you mentioned that 3 of those 22 inquiries are already currently in the cooperation and consistency mechanism. And what that means in practice is that the DPC has concluded its own investigation. It's gathered the relevant information. It's analysed that information. It's made provisional findings on that information. And where applicable, it's also proposed corrective powers. And it's distilled all of that information into a draft decision, which we've then shared with the other supervisory authorities around Europe, who then have an opportunity to object or to comment on those decisions. So as you mentioned, those decisions include Facebook's transfers of personal data here to the United States, TikTok's processing of children's data, and Yahoo's compliance with its transparency obligations. And I suppose just to mention one point that we're certainly seeing in 2022 and in 2023 is that some of the Pathfinder cases that we've already concluded are certainly guiding our further enforcement that we're currently undertaking. So you mentioned that TikTok follows on from the Instagram case concerning children's personal data. And indeed, obviously, the facts are different in each case, and each case has to be analysed on its own facts. But the TikTok case, nonetheless, benefits from these issues having been considered, or some of them at least having been considered in previous enforcement action. And similarly, some people might be familiar with our own decision from 2021 concerning Yahoo's compliance, concerning WhatsApp's compliance with the transparency obligations. There's a 225 million euro fine imposed in that case. And now we have this draft decision at a very advanced stage that concerns Yahoo's compliance with its transparency obligations. So we can see that enforcement under the GDPR is certainly benefiting from all of the work that has gone on in the opening 4 to 5 years of GDPR enforcement. And in addition to those decisions that are already at a very advanced stage, in where perhaps we already have a draft decision that we've shared with the other supervisory authorities across Europe, the annual report reflects that there are a number of other decisions that are at a very advanced stage just prior to being submitted to the cooperation and consistency mechanism. So, this is all detailed in the annual report, but some of those issues, for example, concern Google's processing of location data. Another inquiry concerns Google's processing of personal data in the real-time bidding system. We have a number of inquiries concerning personal data breaches suffered by the Meta group of companies. And we also have an inquiry that's very far advanced concerning TikTok's transfers of personal data to China. We are very close to submitting a preliminary draft of that draft decision that will be submitted to the concerned supervisory authorities at this point, so that TikTok will have an opportunity to be heard on that before we finalize our draft decision to be submitted. The Court of Justice has made judgments on transfers under the GDPR already, and what's quite clear is that there's a significant responsibility on supervisory authorities such as the Data Protection Commission to consider the specific facts of each transfers. If there's not a standard of essential equivalence in the country in which personal data is being transferred to, the supervisory authority must consider whether there are measures that can fill that gap. So that's a complex inquiry that's ongoing, but also is at a very advanced stage as well. So I think in 2023, in terms of what we might be talking about this time next year, I think that our decisions will continue to bring a lot of clarity to the application and interpretation of the GDPR, and they will continue to pursue the issues of greatest consequence to data subjects.
Thanks, Cian. So that's some list across a really wide ranging variety of topics and kind of pillar topics under the GDPR as well. And as I said, we are going to dig into some of those key topics by way of maybe your comments on the decisions that have come to pass already a bit later on in our conversation. For now, I do want to stick with, I suppose, the kind of general overview, the kind of the trends and the high level kind of look back at what has gone on, maybe not just over the last year, but even over the last 5 years, because of course, as you mentioned, the GDPR's 5th birthday is coming up on the 25th of May. And so we're no longer really in the infancy in those very early days of regulating under the GDPR. We are moving into a phase, as you've really usefully outlined, where lots of those core topics have begun to crystallize and become bedded down by virtue of the process of kind of cross-border cooperation through the cooperation and consistency mechanisms. And I suppose when you think back on the GDPR and what it represented when it was just about to come into application nearly 5 years, it was really, I suppose, a huge turning point in the data protection landscape in Europe. It was and it continues to be, I think, one of the most talked about topics globally and internationally in terms of individual rights and the kind of human rights landscape within Europe. We have everyone from the press to politicians to the general population at large. Everybody seems to have a particular topic on how a particular viewpoint on how the GDPR is operating and whether it's living up to its promises that were made kind of in that lead up to 2018. And of course, opinions can kind of vary wildly on those sorts of issues, depending on who you listen to. And that's just one of the challenges, I think, of regulating under the GDPR and for you at the DPC and for other members of the EDPB. So I just want to maybe focus in on that topic of challenge and looking back over the last 5 years. What do you think have been the biggest challenges for the DPC, I suppose, and for the broader role of enforcers of data protection authorities across Europe?
Yeah, sure, Anna. Certainly in the early years of GDPR enforcement, there are very specific challenges that regulators face, particularly because many of the biggest issues of interpretation naturally will come before the regulator, before the Court of Justice of the European Union, and even before domestic courts within Ireland or other jurisdictions have had a chance to interpret the law and to provide binding precedents. So I think there's a big responsibility on regulators such as the Irish Supervisory Authority, the DPC, to take the time to get these issues right first time round, because our inquiries clearly will be precedential in and of themselves, or as we're seeing where there's a huge number of them that are being appealed once concluded, will be precedential when the matters come before the courts. So I suppose there are really 3 main challenges that we faced in the early years of GDPR enforcement, and that's connected to how these issues are coming to the regulator before they've been before the courts. And I suppose the first point being that the GDPR is principles-based and it's technologically neutral, which is one of the great strengths of the GDPR. It means that the GDPR can respond to technology that isn't foreseen now or that wasn't foreseen in 2018. And I think that is a great strength. But it also means that the GDPR doesn't contain pre-packaged answers to all of the toughest of questions under data protection regulation. So it really falls on regulators to interpret the law in the first instance in a manner that achieves the effectiveness of the GDPR in light of its objectives. And the size of that task really cannot be overstated in circumstances where not only is the GDPR principles based, but also it seeks to balance competing fundamental rights. So it's a very significant interpretive challenge. We've seen that the Digital Services Act, for example, has recently been introduced in the European Union. The Digital Services Act contains a definition of dark patterns and also contains a ban on dark patterns. And similarly, the Digital Services Act contains a ban on targeted advertising in respect of children. What we know from 5 years of applying the principles-based nature of the GDPR to these issues is that the GDPR equally applies to dark patterns, because dark patterns could result in a lack of fairness under Article 5.1a of the GDPR, or it could result in invalid consent under Article 6 and 7, or it could result in an infringement of the transparency obligations under Articles 12, 13, and 14, or an infringement of 25 of the GDPR, but in respect of data protection by design. So it's only by applying the principles-based nature of the GDPR to the technology that we're regulating does that law become clear and its application becomes clear. So in some respects, it's unlike the Digital Services Act, which actually defines dark patterns and provides for an express ban on it. So that's certainly been one of the big challenges of GDPR enforcement in its early years. But so you can see from the precedents and from guidance and from court rulings where we have them, these issues are continually being addressed. Indeed, I mentioned that the Digital Services Act contains a ban on targeted advertising for children's personal data. Well, a document that, Anna, you'll be very familiar with is the guidance produced by the Data Protection Commission in 2021 concerning children's personal data, which equally provided in 2021 that by applying the GDPR, children's data should not be used for targeted advertising. So I think there's a big role for regulators in the early years of GDPR enforcement in trying to bring clarity to the GDPR. And I think that can be achieved through hard enforcement, through creating precedents, but also through guidance, as I mentioned. And I think that regulators need to embrace that task, and certainly something that the DPC has been doing. We've mentioned all the action in respect of children's data, the Instagram decision followed up by the TikTok decision. And in the middle of all that, we have our guidelines as well. So it's certainly a task that we are pursuing. The second main challenge we've noticed in terms of enforcing the GDPR over the early years of enforcement, which perhaps now we're currently leaving those early years of enforcement. But the second challenge is the lack of certainty in terms of procedures. I know we're going to talk in a little bit more detail about how the one-stop shop operates and how that mechanism operates, where we have to share draft decisions with other supervisory authorities concerned. There's certainly a lot of uncertainty as to how that should operate, and it's very welcome that the European Commission is currently proposing further harmonization of the rules as to how that should operate. It's further uncertainty in light of the novelty of the issues we're handling under the GDPR in terms of vindicating and ensuring the right to be heard for regulated entities, particularly where our corrective powers can be so consequential. And finally, one of the other challenges we've been facing in early years of GDPR enforcement is applying the GDPR to complex technical operations for the first time, and the types of technology that the GDPR regulates. For anyone who's familiar with the GDPR, a word that you'll frequently see is the standard of necessity and whether something's necessary. And similarly, a word that's repeated across many different articles is the standard of appropriateness. So in order to apply those types of standards, you've really got to understand how the technology operates and the nuances of the technology, and apply the law in a way that reflects which measures may have been implemented and whether they are appropriate, or which reflects whether the specific processing that's ongoing is necessary for a particular purpose that's being achieved. So I think that really reflects the main three challenges that we've been facing. But as more and more time goes on and more enforcement ramps up, we're seeing more and more clarity being brought to these issues. So it's certainly a very positive place that we're entering into now in terms of enforcement.
Thanks, Cian. So I suppose a few kind of comments in response to what you've said there. So clearly regulators firstly have a huge amount on their plates. Nobody can underestimate the range of issues and the ramifications of those issues in terms of what you're dealing with. And of course, the GDPR has been groundbreaking both in its application and in its enforcement. When you think of the types of the decisions that the DPC has brought forward, dealing with, as you said, new technologies which are being dealt with through the lens of the GDPR and the obligations for controllers and processors for the first time. But of course, when you step back from the substance and the content of what the GDPR itself is intended to tackle, the GDPR as a kind of a European regulatory instrument was, of course, groundbreaking in the way that it was set up, groundbreaking in its novel pan-European regulatory structures, groundbreaking in that it provided for never before seen systems of co-decision making, which we've talked about under the cooperation and consistency mechanisms, and of course, dispute resolution as well under Article 65 of the GDPR. Now, you've talked a lot about the crystallization of lots of the themes under the GDPR through the decisions that have been issued by the DPC, and clearly there's a lot of positivity, a lot of developments and kind of bedding down, I suppose, of what the GDPR is all about that has taken place over the last 5 years. But of course, the operation of the GDPR as a whole and of its structures, particularly those, I suppose, interdependent data protection authority roles hasn't all been plain sailing. There has been a bumpy road at times, as we have seen certain of those mechanisms take effect and be, I suppose, implemented in practice through real life decisions. We've seen the dispute resolution process, which was really intended under the GDPR as a measure of last resort, be activated on a number of occasions when cross-border processing decisions have been brought through to the European Data Protection Board under Article 60. We have seen patterns, I suppose, emerging as detailed through visual aids in the DPC's annual report of certain groupings of data protection authorities raising objections to decisions brought by the Data Protection Commission. And now, of course, we have arising from the trio of meta decisions, that's the WhatsApp, the Instagram and the Facebook decisions concerning reliance on contracts as a legal basis for processing. We have seen the DPC take annulment action proceedings to the Court of Justice of the EU in connection with what the DPC has deemed to be an overreach by the European Data Protection Board. So there's still an awful lot of complexity, an awful lot of issues around those interoperational structures that need to be ironed out, and maybe some of them will not be ironed out until a new wave of cases have come before the Court of Justice. So I suppose when you look at all of those different factors, those different complications in the bedding down of the GDPR as a brand new European law, where do you think that kind of comes out in terms of an assessment of how the GDPR cooperation and consistency structures are operating in practice?
Yeah, sure, Anna. Thanks for that. I think, it's always important to go back to basic principles under the GDPR when interpreting it and when applying it. And the basic idea behind the cooperation and consistency mechanism is to harmonise the application of data protection law around Europe. So what this means in practice for the Irish Data Protection Commission is that all of our cross-border inquiries need to be submitted to the one-stop shop mechanism, and any of the 48 supervisory authorities around Europe have a right to object to any of those decisions and to raise a relevant and reasoned objection. And as you mentioned, Anna, that can lead to the dispute resolution mechanism if it's not possible to resolve the objection. So there has certainly been a lot of focus on the points of disagreement between the various supervisory authorities, but the main point I'd like to make at the outset is that we certainly agree far more than we disagree within the process. You mentioned the annual report that sets out which all of the DPC's decisions that have entered the process and where we've received objections. But also further to that, some of our big decisions that I've already mentioned today didn't receive objections. For example, in the case of the Facebook scraping decision and the Facebook 12 breaches decision, those decisions were concluded either without any objections, or in one case, we received 2 objections, which were withdrawn during the process. The Instagram Children's decision, which contained the largest fine so far, €405 million, that level of fining was what was originally proposed by the DPC in its fining range that was proposed to the other supervisory authorities. So we certainly agree a lot more than we disagree, but in terms of the points of disagreement, there certainly are some challenges under the one-stop shop mechanism. The first challenge I'd like to point out is that any uncertainty in the law, it can be quite problematic for the mechanism in terms of how it operates. And we know that there certainly is significant uncertainty still under the GDPR as to how it applies. So the GDPR is being applied in 27 different legal frameworks by 48 different supervisory authorities. So it's quite natural that there might be different views on the correct interpretation and the correct application of the GDPR. And indeed, sometimes objections received on a draft decision from one supervisory authority might contradict objections received by another supervisory authority. And all of this enforcement is taking place on a cross-border level, while in the background, we also see each supervisory authority engaging in domestic enforcement, and indeed domestic courts making decisions on the correct application and interpretation of the GDPR. So naturally enough, domestic authorities do feel obliged to put forward earlier positions adopted in other domestic cases. The vast majority of those domestic cases, of course, don't make their way through the one-stop shop mechanism. Similarly, the timeframe for the one-stop shop mechanism can be challenging. You know, the Instagram children's data decision contained very significant positive measures for children, and nonetheless, it took 9 months for that decision to make its way through the mechanism. And of course, that's after all of the relevant information has been gathered and analysed and provisional findings made by the Data Protection Commission. And I think it's also a resource-intensive mechanism. We know last year, as the DPC's enforcement was ramping up in terms of our inquiries reaching conclusion, at that point, the European Data Protection Board and the European Data Protection Supervisor wrote jointly to the European Parliament and the European Commission seeking additional resources in light of the amount of work required and the amount of resources required to bring decisions through the one-stop shop mechanism. However, despite all of those challenges that certainly do exist, we have to remember that there are a range of benefits of the system as it exists. It's certainly very effective at bringing clarity to the law and at providing precedential authorities on the correct interpretation and application of the law. Perhaps the best example of this is the DPC's own decision concerning WhatsApp and WhatsApp's compliance with its transparency obligations. In that case, the DPC put forward an interpretation of Article 13(1)(c) of the GDPR, which the other supervisory authorities fully agreed with and embraced, despite some strong objections from not only WhatsApp, but from other large technology platforms in terms of how they comply with the transparency obligations. So that brought a lot of certainty to that point of interpretation. But similarly, it brought a lot of certainty on points where there was disagreement, and particularly around the calculation of fines. There was a particular point about applying fines for the same or linked processing operations, in which there was a lack of certainty in the law. The DPC took one approach, which other supervisory authorities disagreed with. There was ultimately a binding decision which set out EDB's approach, and the Data Protection Commission has been applying that approach to fining ever since that binding decision. So we can see how the one-stop shop mechanism does bring a lot of clarity to the correct interpretation and application of the law. And indeed, that particular decision in WhatsApp predates any fining guidelines from the EDBB, which are currently still being drafted. It also provides a valuable mechanism for dispute resolution where there is disagreement between the supervisory authorities. And as I mentioned, most of the big issues are going to come before the supervisory authorities in the one-stop shop mechanism for the first time. So it's a mechanism that can bring clarity to these big issues moving forward. And finally, as well, we have to remember that when we're regulating data protection law, we're regulating a fundamental right. We're not regulating simply market conditions. So the one-stop shop provides not only for harmonization, but also proximity between a data subject and their local supervisory authority, and then enables subsequent harmonization around Europe and a consistent application of the GDPR around Europe. So the one-stop shop has certainly been a very interesting mechanism and a novel mechanism, not only in EU data protection law, but I think it's fair to say in EU law generally. And we've certainly gained a lot of lessons from the correct interpretation and application of various different provisions in the mechanism so far.
Thanks, Cian. I suppose kind of sticking with that topic again of the groundbreaking features of the GDPR, one of the very notable aspects of GDPR that had a huge amount of attention paid to it and continues to do so is the possibility of mega fines. And we're talking kind of lottery ticket numbers in terms of the scale of the potential fines being imposed. And there has been a kind of a fixation, if it's fair to say that, a lot of attention paid, particularly in the press, to the top level of those fines, and the fact that, you know, in many cases, as you have mentioned, there have been very, very significant fines running to the hundreds of millions levied against household name companies. But of course, fines are really just one tool in the kit of regulators under the GDPR. There's, of course, a range of corrective measures, other corrective measures that can be imposed by regulators, but we really don't see much heard or said or reported on those other tools in the toolbox of regulators. But of course, when you think about it from a compliance perspective, and I suppose from the legislative intent perspective of the GDPR, changing behaviours and increasing compliance and increasing protections of fundamental rights for data subjects is really what the GDPR is all about. And those kind of changes in behaviours of companies and organisations that are processing particularly large scale volumes of data really could only be achieved through directions to change existing operations, existing practices, and sometimes with bans or temporary suspensions on processing. So I suppose one of the things I think would be interesting to hear from you is how does the DPC go about actually ensuring that when it does impose those corrective powers, those bans, those directions, those orders to bring processing into compliance, and I understand it has done in every single big tech decision that is issued under the GDPR to date, how do you make sure that those are actually complied with, particularly when faced with possibly numerous types of appeal and legal challenge to some of the decisions that the DPC has made?
Absolutely, Anna. As you mentioned, in many cases, it would be appropriate to impose fines alongside other corrective powers like orders and bans. And that's certainly from the DPC's record so far, something that we have done in many, many cases. We also have an enforcement unit in the Data Protection Commission whose function it is to follow up with corrective powers that are exercised after the final decision is made. So that team is responsible for scrutinizing what changes a regulated entity has made after the final decision to bring themselves into compliance and to comply with any order or ban or whatever other corrective power we may have exercised either instead of or as well as an administrative fine. So a good example of that, perhaps simply because it relates to a decision that was issued in 2021 and it's not one of the more recent ones, is the WhatsApp transparency decision, which included an order as well as the fine requiring WhatsApp to make a range of changes to the information it provides to data subjects and changes to its privacy policy. In that case, the DPC followed up with WhatsApp and with the timeline that WhatsApp was given to comply and ensured compliance. And indeed, WhatsApp did bring itself into compliance, and that compliance was verified by the DPC. More recently, you mentioned the contract as a lawful basis to process personal data and how those decisions concerning Facebook, Instagram, and WhatsApp have concluded recently. In each of those decisions, the DPC included fines, but also orders requiring Instagram, WhatsApp, and Facebook to identify a valid lawful basis. You may have seen last week that Facebook announced publicly that it will be relying on 61F, which is legitimate interests under the GDPR for some of this processing going forward. So certainly the DPC will be following up on the order made and scrutinizing compliance in light of how under Article 5.2 of the GDPR, entities are required to be able to demonstrate that the processing is in compliance. I think as well, Anna, you mentioned a very pertinent point about appeals, and it's useful for entities to be aware that where they do appeal against a decision of the Data Protection Commission, as a matter of Irish law, there is not an automatic stay placed on any order. So if the DPC makes an order requiring certain action, and if an entity appeals against that order, the order is still applicable pending that appeal, unless the court ultimately places a stay on the order in question, which the court would have to consider where the balance of justice lies in considering such an application for stay if it was made. So that's just another point to remember. And tied in with that as well is that what we've seen not only from the Irish Data Protection Commission, but also from other entities and other regulators around Europe, the timeline for compliance is a key issue when making an order or a ban. How long should a regulated entity have to bring itself into compliance where the orders may require significant changes to various infrastructures? And what we've seen so far is that in most cases, the timeline that's appropriate to bring processing into compliance is relatively short. I mean, a lot of the DPC's decisions have had 3 months to bring processing into compliance, sometimes 6 months. I know that other entities around Europe, other regulators around Europe have imposed similar timelines. So when a regulator is considering what is an appropriate timeline to bring processing into compliance, really a crucial issue is that ongoing infringements can pose a risk to the rights and freedoms of data subjects. So that's one issue that really balances in favor of shorter timelines and achieving what is possible in a shorter time frame. So we're certainly very busy, not only in imposing those corrective powers that I mentioned, but also in following up after the final decision is issued.
Thanks, Ken. So I just want to maybe step back to that trio of decisions that you've mentioned a number of times this afternoon involving Meta and WhatsApp and Instagram in relation to the legal basis under Article 6.1b of the GDPR, which of course relates to processing which is necessary for the performance of a contract. Now, those decisions, I think anyway, I haven't done a survey on this, but my sense is that those decisions have generated more commentary amongst privacy professionals and the privacy community in particular than possibly any other decision that has come out of the DPC or in fact any other data protection authority in Europe. And when you think about it, that inevitably is because it goes to the very core of the pillar obligations that apply to data controllers under the GDPR, being that you must have an appropriate legal basis to rely on to justify or to ground the processing of data that you undertake. And certainly, you know, my sense of it is that these decisions are causing a lot of organizations to reassess their own legal basis that they had identified as an appropriate legal basis for processing data within their own organizations, particularly, of course, where the processing involves serving personalized advertising and then service improvements for safety and security as well. So I'm interested just in maybe just hearing your views, and if you can give maybe a little bit of advice for businesses that are now faced with this quandary, where they're, you know, concerned about being in a similar position where they could be hit with directions or orders to bring processing into compliance, or directions, I suppose, that would cause them to have to reevaluate and possibly restructure the very essence and the very core issues at their data governance or GDPR compliance program. What is your advice as the regulator for organizations that are concerned at that prospect?
Thanks, Anna. I'd certainly really advise all entities to focus on data protection by design when designing their systems, when designing their products, and when designing their features. This is obviously an obligation under Article 25.1, so it's required anyway. But by really thinking creatively about how to implement the measures at design stage, I think that, you know, entities can insulate themselves from future orders to some extent if infringements are ultimately found to be ongoing. Perhaps one of the best examples of this is the Facebook 12 breaches decision that the DPC concluded. It was a decision that looked into 12 personal data breaches suffered by Facebook. They were caused by software bugs, and the decision ultimately looked at Facebook's coding practices and found that there was no infringement of the security principle under the GDPR because the coding practices were really state of the art. But nonetheless, the DPC found a separate infringement of Facebook's obligation to be able to demonstrate compliance with the GDPR, because while Facebook did have state-of-the-art coding practices and policies in place, in the particular instances, it failed to demonstrate compliance with those policies in the specific instances that led to the bugs. So a draft of the decision that the DPC ultimately issued proposed an order for Facebook in that particular case. However, by the time we came to a final decision, Facebook had demonstrated that it already brought itself into compliance, and it was able to do so, perhaps largely in part because it had implemented the security principle by design, and the infringement and the order that was made related to the accountability principle, and was Facebook was able to comply by the time the final decision was issued. It's something that we see regularly enough. I mentioned that the timelines for compliance are relatively short in many of the decisions, but in many cases, what we're noticing is that the inquiry alone is sufficient in order for entities to bring themselves into compliance. For example, the Instagram children's data inquiry, one of the big issues in that inquiry was that when children created Instagram accounts, by default, they were made as public accounts. But by the time the Data Protection Commission's inquiry concluded, that was no longer the case. So there was no order required in respect of a particular provision of wrongdoing that was ultimately found to be occurring. So that's the best advice I can give to entities who are concerned about just how serious the corrective powers are under the GDPR and just how short those timelines for compliance can be. You can really, by focusing on data protection by design, you can really protect future processing operations from disruptive orders by attempting to implement the principles and to be creative about implementing the principles from design stage.
Thanks, Cian. So just, I suppose, picking up on a couple more points that you've made, both in your last answer and I suppose earlier in our conversation. The thrust of what we've talked about to date has been fines. It's been the other types of corrective measures, those bans, those directions and compliance-based orders. And all of that, of course, falls within the space of hard-edged enforcement. In other words, enforcement that has flowed from a more formalistic kind of methodology deployed by a regulator, mainly by way of investigations and inquiries that you've conducted. But I suppose I'm interested in, is that the be all and end all of what regulation under the GDPR is all about? Or is there space for a more collaborative and possibly less punitive, less sanctions-based approach to be taken by regulators? Now, I know, of course, across Europe, there are variations in the way data protection authorities can see their roles. But from the DPC's perspective, is there a place for a less hard-edged approach, a more collaborative approach with organizations to encourage compliance?
Yeah, there certainly is, Anna, and you're correct that this isn't necessarily consistent around Europe. But from the DPC's perspective, we've been particularly strong on balancing the requirement for that hard-edged enforcement that we've been talking about today in terms of the corrective powers and the orders, but also using the other provisions provided for in Article 57 of the GDPR of guidance and consultation functions. Naturally enough, the big decisions that we're talking about are concerned with ex post enforcement and are concerned with responding to wrongdoing where something goes wrong. But that sort of ex ante enforcement that comes in the shape of guidance and consultation can prevent harm and can prevent wrongdoing before it happens. So this is something that the DPC has placed a lot of emphasis on. For example, in 2022, we received 322 consultation requests. In 7 of those cases, large online platforms either suspended planned changes or proposals or revised changes based on consultations with the DPC. One example of that is where TikTok announced last year that it was switching from consent as a lawful basis for behavioral advertising to legitimate interests. And the DPC had a range of concerns about this, engaged in a consultation with TikTok, And as a result of that consultation, TikTok has delayed its switch from consent to legitimate interest. And that engagement between TikTok and the DPC remains ongoing. I mentioned as well how Facebook has announced that it's seeking to rely on 6.1F legitimate interest as well, instead of 6.1B in that case, instead of the contract basis, which has been found to be unlawful. Another very important example of this, it relates to when Facebook was rolling out its dating feature in Valentine's Day of 2020 before COVID, which seems so long ago. And the DPC had a range of concerns about this feature that Facebook was rolling out, engaged in consultation and couldn't acquire certain documentation. So actually carried out an inspection at Facebook's offices in Dublin to obtain the relevant documentation. As a result of that, Facebook delayed the rollout of the Facebook dating feature. And when it did roll it out the following year, it made a range of changes, ensuring that special category data, the most sensitive of data, wouldn't be used for targeted advertising, and also ensuring greater transparency in terms of how it would undertake its processing in relation to the Facebook dating feature. So I think a balance between all of the features and all of the obligations and functions of a supervisory authority under GDPR is the appropriate approach for a supervisory authority to take, balancing both the hard enforcement options as well as guidance and consultation, which can achieve things that the hard enforcement options can't achieve.
Thanks, Cian. So I think it's really interesting and really valuable for regulated entities to appreciate that it's not all about fines, it's not all about ex post enforcement, that there is this opportunity, I suppose, to kind of engage with regulators in advance and to try and get things right as they roll out new products and services. I'm conscious of time. I think we're probably coming up on the close to the 50 minutes, but maybe if I could just before we finish up, if I could circle back to one of the themes that we touched on earlier, and of course that's the 5-year anniversary, the 5-year birthday of GDPR coming up on the 25th of May of this year. So the instrument is no longer an infant; it's now a school-aged child. So I suppose just on that birthday theme, can I ask you, overall, is your sense that there is much to celebrate in terms of the GDPR and that big 5-year birthday?
Yeah, and I certainly think there's a huge amount to celebrate in terms of 5 years of GDPR enforcement at this point. So firstly, one of the main points to celebrate is how the GDPR has raised awareness of data protection amongst members of the public all around Europe. It might be interesting for an American audience here today to hear that, the general public are very much aware of what the GDPR is. It's almost a layman's term now. It enters into common parlance and is very much something that people are aware of. And as a result of that, and how the DPC equips data subjects, it means that data subjects are exercising their rights under GDPR, and all supervisory authorities around Europe are seeing how that awareness of the GDPR is making sure that data subjects exercise their rights under the GDPR. Just last year, the DPC received just under 30,000 contacts to the office from people trying to either exercise their rights, make complaints, just ask questions about data protection law. So it's a huge number of contacts received by the office. I think secondly, a second cause for celebration is certainly the enforcement in the first 5 years of GDPR enforcement. I think by any objective standards, it's been a massive success in terms of enforcement, and many of the challenges that you'd expect from a new piece of legislation and a new regulatory regime have been overcome. As I mentioned last year, in year 4, we had 1.62 billion in fines around the European Economic Area and the UK. The DPC issued over 1 billion of that. And just to contrast that with the competition law or the antitrust law enforcement mechanism that was introduced to the European Union in 1962, the very first fine under that mechanism came in 1969. That was a $500,000 fine, which was ultimately reduced to $65,000 on appeal. So I think, as I mentioned, by any objective standards, enforcement under GDPR has been a massive success. And as we start to see more clarity being brought to the law, by either regulators, by the ETBB working together, and ultimately by the courts, I think that enforcement will become quicker and it'll become more certain, and there'll be even more of it. And finally, as well, I think one of the big successes of the GDPR is that it has led this wave of digital regulation that's coming from Europe, and in which Europe is really leading the world in many respects. The Digital Services Act and the Digital Markets Act are new pieces of legislation, which I think can gain a lot from what we've learned from the first 5 years of the GDPR. So I think there's certainly a lot to celebrate. And it's been a massive success to date and will continue to be.
So Cian, any big cause for celebration causes for a great big birthday cake as well. So as you and your colleagues at the DPC wheel out that fifth birthday cake for the GDPR and you're blowing out the candles, what will be on the wish list for the next 5 years?
Yeah, well, perhaps the first gift I would hope for is how there are currently 45 references before the Court of Justice of the European Union concerning data protection matters. So perhaps 45 gifts there in terms of this Court of Justice bringing clarity to the correct interpretation and application of the law, which I think will bring more certainty and will certainly help enforcement. I'd also hope for a lot of valuable coordination with the other digital regulators around Europe, including under the Digital Services Act and Digital Markets Act. I think that will be really crucial for regulators to work together in terms of regulating the same platforms. And finally, I suppose another point perhaps is we've seen in the first 5 years of GDPR enforcement how many different jurisdictions around the world have adopted similar data protection and privacy regimes. And I think it would be really positive to see that trend continuing because we've seen how empowered data subjects are by such regimes. And similarly, it might also help regulators for more jurisdictions around the world to have a similar regulatory regime, which might result in more adequacy decisions from the European Commission and would help us in terms of the transfers enforcement. So I think there are a few issues that we'd like to see in the next 5 years of GDPR enforcement.
I think lots of people would share your aspirations for those wishes, Cian, and I certainly hope all those wishes come true. So I think we have kind of reached the limit of our time. I can see Justin approaching the stage again. So just to say, Cian, it's been such a pleasure talking with you today and sharing a stage with you. And thanks so much to Justin and the team for this opportunity to discuss European enforcement over the last 5 years.
Yes, thank you, Anna, for all the insightful questions. And thank you as well, Justin.
Yeah, Cian and Anna, that was a fantastic discussion, and it covered a ton of topics on enforcement. I know we're out of time. I want to be respectful. I'm guessing you both are very, very busy around town today. On behalf of everybody joining today, Cian and Anna, thank you very much for that outstanding session, and I hope you both will join us at another Spokes.